So thank you very much, everyone, for choosing to listen to this webinar, which I hope will prove useful to you in your practices. So I've taken up the mantle today to talk to you all about frightening cross-border issues in bankruptcy. Now, these are issues which we always hope do not crop up when we speak to a client or read the papers for the first time. And indeed, not many people really like picking up Dicey, Morris and Collins on the conflict of laws either. However, it appears that ever since I completed my part-time master's in international commercial law a year or so ago, cross-border work keeps falling on my desk more often than not. And this has given me the opportunity to develop my knowledge and skills in this area. So today, I will be talking to you all about jurisdictional issues in bankruptcy, setting out some key points of law, practice and procedure that may assist you all in the event jurisdictional issues come your way. Now, the reason I'm talking about this particular subject is because over the course of 2024 and 2025, I was extensively involved in a set of heated bankruptcy proceedings where the issue of jurisdiction was front and center. The conclusion was reached in the first half of 2025. Now, it is common practice to assert in a bankruptcy petition that the debtor's centre of main interest, what is known as COMI, is in England and Wales. But it's not so common practice to assert further or alternative grounds of jurisdiction. And indeed, the usual form of bankruptcy petition does not actually refer to alternative grounds of jurisdiction either, with any real sort of clarity. However, when dealing with bankruptcy proceedings, parties and legal practitioners may come across jurisdictional issues. It's therefore important to ascertain what grounds of jurisdiction are available to a petitioning creditor and what the applicable tests are to make out those grounds. So as I mentioned earlier, having dealt with my own bankruptcy case involving an extensive and heated jurisdiction issue, other questions arise too. Namely, does the court need to decide a debtor's COMI in any event, even if an alternative jurisdiction ground is made out or is to be made out? And also, what is the position regarding alternative grounds of jurisdiction if a debtor's COMI is outside of England or Wales altogether? So this webinar will address those issues and also provide some useful guidance with regards to points of practice and procedures that relates to the framing of a bankruptcy petition, the notice of opposition and written evidence. And also we'll look at the important role that cross-examination plays of a debtor in these circumstances. So I set out on screen the agenda for this webinar. So I'll be discussing the following points of law. The first is the grounds of jurisdiction under Section 265 of the Insolvency Act 1986. That's the pertinent provision which provides for those alternative grounds. Then I'll be focusing upon the applicable tests that make out those grounds of jurisdiction. And then the key concept of COMI and the question of whether or not the court needs to decide COMI in any event, even if an alternative jurisdiction ground is made out or has been made out.